Yes, yes. Is there a reason why you're pushing that back?
Just to be able to see, is that no good?
All right.
I can push it forward. No, I'll leave it.
And make sure he's not in the waiting room for Zoom. It's open. And we confirmed with him today that he was coming.
Did he know the right time? Was he thinking he said 7 instead of 6:30?
He got the agenda. We said 6:30.
I think I have Wayne's cell phone number, I believe. I can give him a quick ring, just make sure and he's not mistaken as the time.
Karen might be calling him right now.
Okay.
Okay, you talked through it.
Good, I was feeling pretty lonely here.
What's that?
I was beginning to feel a little lonely here.
Yes,
Yeah. He's just on Summer Street. He'll be here any minute.
probably locked out.
Sure.
sure we met before. Steve Sayers.
Brian.
Good to see you again, see, first time in person, nice.
Yeah, that's right.
We've always been on Zoom.
Nice to be in person.
Yes.
Mr. Barry? Sorry.
No problem.
We figured you were locked out. No, I had a minor cat emergency. I know, seriously.
Are you ready to go? Ready, Wayne?
Okay, Stephen, we're all set.
Okay, I'm going to call this meeting to order. This is a meeting of the Kennebunk Zoning Board of Appeals, March the 6th, 2023. I've been asked, in view of the chair's regrettable incapacity, although not evident in any way, to be the chair pro tem of this meeting. So I will call the roll here. Leah Rachin.
President Brumley, thank you.
Wayne Berry.
Present.
And Stephen Sayers present. Not present is Paul Brunel. Also present is John Sevigny, who's a member, but he's recused himself altogether from this hearing. He's actually appearing in the capacity of appellant. So it appears that we have a quorum, and we're here to consider an administrative appeal under Article 6, Section 2A, filed by Mr. Sevigny in his capacity as appellant. And the order is not going to be any out of the ordinary at all. It's going to be Mr. Sevigny proceeding first as the appellant to present any evidence and arguments that he wishes. Then Mr. Kunkel will make his presentations either personally or as his counsel here. And could you just identify yourself, sir?
Good evening, members of the board. Ben McCall, on behalf of the code officer tonight. You have separate counsel, I believe, who will be introducing himself.
And we have received your February the 24th, 2023 letter. Mr. McCall, thank you very much. And other counsel?
My name is Jim Katsafikis with the law firm Perkins Thompson. I'm here tonight representing the Board of Appeals, and with me is my associate, Melanie Dorn. Thank you.
And without further ado, Mr. Sevigny, the floor is yours. Microphone.
Hello? All right. I'm going to start up here, and then I'm going to move to the laptop and kind of do a presentation. So, good evening. I would like to thank the board for your time and your service to the community, as well as to the people of Kennebunk who are here today. My name is John Sevigny, and I live at 15 Longwood Drive here in Kennebunk. This property went on the market in the fall of 2021, and we were one of the first potential buyers to look at this property. We lived in West Kennebunk and wanted to move closer to town and the ocean. We instantly fell in love with the neighborhood, the land, and the house itself. We knew about the new house lots adjacent to the property and was assured that there would be minimal cutting in the new lots due to wetlands, and it would have very little impact to our property. We closed in early January of 2022. This is also the same week that Bob Centauri cut down all the trees on 17 and 21 Longwood Drive. He was the new owner of the two lots. I actually talked to Brian Paul, who is present here today, on that day, and he assured me that he was on top of this matter and would make sure that Bob had to replant the forest that he illegally cut down. We absolutely love the house, the land, and the neighbors of Longwood are wonderful people. The only issues we have experienced have been with interactions with Mr. Centauri and the lack of code enforcement on the two properties. I am really looking forward to the sale of these two homes and meeting the new neighbors. I am not here to be divisive or cause any issues with the town. I only want to protect my land and investment in the community of Kennebunk. I know that everyone is busy and the housing market has been crazy, so I understand that the town is overloaded with new homes being built in the community. However, we need to hold the town and the builder of these homes accountable. There were specific conditions put forth by the Kennebunk Planning Board that needed to be followed in order to build on these lots. I have watched the Planning Board meeting from August 9th of 2021, and it is very clear that they were concerned with the drainage and stormwater issues that could happen from the construction of these two homes. Their concerns have materialized, and the road was actually flooded in the fall of 2022. I am also experiencing flooding along the property line with both lots. My goal today is to hold the builder in town accountable for their actions. The drainage and stormwater issues need to be fixed, and the wetland needs to be replanted correctly, or an escrow account needs to be set up to make sure that it is. I do not want the future owners to inherit these issues and cause tensions in the neighborhood. Codes and laws are created to protect the land and people of Kennebunk. When the codes and laws are not upheld by the town in which we all live, the land and the community suffers. I'm going to go through my application and the evidence that I have within the application, and then I have some other pictures and diagrams and things to show. So I am appealing the decision to grant a CO to 17 and 21 Longwood Drive based on the following. There is water runoff from 17 and 21 Longwood Drive that is adversely affecting my property at 15 Longwood Drive along the property line. The water is pooling in places that did not have this issue prior to this construction at 17 and 21 Longwood Drive. The runoff is also adding to substantial water to an area that had pooling in the past. And when this started happening, I looked up the laws and codes, wondering, there's got to be something that doesn't allow this. And I found that per Title 17, Chapter 91, Nuisances, Section 2802, Alteration of Surface Water, unreasonable use of land that results in altered flow of surface water that unreasonably injures another's land or that unreasonably interferes with the reasonable use of another's land is a nuisance. So it's against the law to have water draining onto your neighbor's property. Robert Santori should fix the drainage issue he has caused at 15 Longwood Drive and drain the water legally. This could be done by a simple French drain along the border. Also, number 2, there were not enough trees planted while replanting the wetlands that were illegally cut down. Replanting plan done by a professional forester was not followed. The replanting plan called for 88 trees and only 20 or so were actually planted. The forester also recommended an escrow account for future plantings if not all the trees were planted. And I have evidence of this in a later slide. And then also, the exterior stair sets do not meet code at both 17 and 21 Longwood Drive. Both should have exterior handrails as required per the 2015 IRC code when there are 4 or more risers. So this picture that you see here is actually right after they backfilled the foundation. And as you can see, it is sloped directly into my yard. You can see that line, string actually, that kind of forms the border between the two properties. And this is just the initial grading. When it was actually fully graded, it got even steeper and came directly past the line onto my property. The bottom picture or image is showing the trail that I utilize to access my backyard. Now this trail typically is dry, or was dry, so that I could walk along this line, and there are areas in the backyard that me and my family use. There's a swing that's been set up, a bench, and other like little bridges. It's really cool back there. And this is the main way that we all get back there. Since the houses have been built, this area is very wet and puddled with water, and it makes getting back here difficult. So when I got this is an email I sent to the town with that law that I described in the intro. I sent this to Chris, Brian, Frank, everyone in the town, just so that they were aware that what was happening at 17 and 21 Longwood Drive is essentially illegal, and there are laws that prevent it. So I wanted to let them know, and had hoped when I sent this that they would take care of it, you know, being the town and looking out for people in the neighborhood. So here is some emails regarding the ponding at 15 Longwood Drive. Now this first email is from a neighbor that's lived in the area, I want to say almost 20 years. Her name is Leslie Lindgren, and she's actually here today. And in that, she does say that she has been in your backyard numerous times over the years, and I never, capitalized, remember seeing puddling in the area to the left of the pond and beyond the stone wall. And she used to be over at the house many times, whether it was to chat, look at the ducks in the pond, the turtle nest, grandson using the trampoline, or meet up to walk the dogs, or have a fire pit by the pond. So she had been there many times over the years and, you know, basically did not see any kind of the ponding, puddling that we're seeing currently. And then the next email is actually an email from the prior owner that talks about the wet backyard. And it essentially says, you know, she wasn't sure where I was claiming the water is puddling, but the area behind the house, behind the pond, and the left back of the pond was always wet and puddling in the wet seasons. Then in drier seasons, like late summer, it wasn't as wet and never completely dry in any season. Now this is not the area in question. This was talking about behind the pond. And she goes on to say, also in that area, I described above is wet because that's the area that catches the water that flows down from Chuck's house, who is my neighbor to the other side. There's a stream-like area that flows from Chuck's yard into and behind my former pond at 15 Longwood. Then the water flows down to Lindgren's house. So there is water that flows behind the house, and that is along the eastern border of the house, and that's not in question. And I know it's wet, it's always been wet, and there's actually little bridges and things that go over that area. So this email, which Chris had used in his determination, is not talking about the same area that I am questioning. So the bottom part of this, and this is from Chris Ostrader, the town engineer, and this is what he had sent to Frank prior to Frank giving the CO to 17 and 21 Longwood Drive. And in his notes, and what he could ascertain from reviewing everything, was that there is some residual runoff from the development that does drain toward the common property line along the rear. So this statement essentially is saying, yes, there is water draining from 17 and 21 Longwood Drive into 15 Longwood Drive. And then he goes on to say that this area receives runoff from several sources in addition to that of 17 and 21, which is true. There is a section of my yard that does flow into the area, and I'll show you on maps where that is, that we had kind of a ponding area prior to this, but not along the trail. And then also, the next part, it does say the topography based on the testimonial of the prior owner was used in his determination. And I just read what her testimony was, and it's not referencing the location that is under scrutiny here. Goes on to say that the redirection of off-site drainage is not under the control of Mr. Santori. Now, that is something that is under his control. He could have easily built a French drain to mitigate the water around, you know, along the fence line and then into where all the water's draining down towards Leslie Lindgren's house. And it did say that provided, he said that you could give a CO if it adheres to all the code's restoration conditions of approval and ordinance requirements, and it did not adhere to the codes or laws of Kennebunk and Maine. So this is a excerpt from the planning board minutes, and this is what the planning board approved. Now you'll see number 4 under erosion, that the planning board required a grading and drainage plan be submitted, reviewed, and approved by the town engineer prior to the issuance of a building permit, with the intent that the development of this parcel will not adversely affect the surrounding neighborhood. Also under 14, the exact same wording for a grading and drainage plan was to be required and approved by the town engineer. And this note is a note I made, that the conditions that the planning board had sent forth were not met by Mr. Santori. The neighborhood has been adversely affected by the drainage issues caused by the construction of both 17 and 21 Longwood Drive. The road was actually flooded in November of 2022 due to these drainage issues. The town forced Mr. Santori to fix the issue along the road. My land is experiencing ponding that was not there prior to the construction of these homes, and Mr. Santori needs to be held accountable to the conditions that the planning board had already stated. So the planning board was worried about the water runoff, the stormwater, and the drainage of these properties. So they were trying to make sure that what has occurred did not occur. Unfortunately, it was not enforced by the town. So this map right here is showing the 2 lots. I don't know if you can see my cursor, but this is 21 Longwood, and this is 17, and this is 15 Longwood Drive where I live. So this area right here is actually a new ponding area that never had ponding or any kind of water issue. And during, heavy rains, we get a little pond right there. This green area is where we actually have some runoff from our house go into it, and that was known, and it's a low spot, and that's fine. Unfortunately, what's happening is extra runoff from here is going into that area as well, and making that a very, very large area now. And then the third area in question is this new ponding area along here. Now that area is the biggest issue we're facing because it is the main route we have to access our backyard in order to utilize the land that we purchased. And you'll notice that we do have wetlands here, and they're low topography. But because of the runoff here, we are getting ponding here, so we're basically having to walk through puddles in order to get to that land in the back. So this photograph here shows the ponding prior to the construction. As you can see, there was an area that we would actually get runoff from our house and create a little puddled area. Now after the construction, what has occurred is this ponding area has over doubled in size and then starts running along the fence because we are getting runoff from 17 Longwood Drive. And from the map that was done by, let me get the name, Lower Village Survey, and that was done December 29th of 2022. They actually went out there and took points on both properties. And from those points, you can actually see where the water wants to go. Water always travels down, it's gravity. So these green arrows show basically water flow lines. And as you can see, they are flowing directly to the border. And this dark blue line right here is the border. And so they're flowing off of 17 Longwood Drive onto my property. And all the elevation points are proving this because as the elevation points get lower, water wants to go to the lowest point on the land, and it's traveling down to my property. What Mr. Santori basically did was he took a low area of wetlands and grade and he built it up. And I have another diagram that will show that in more detail, but he built it up in such a way that he's actually draining it down towards my property. He does drain it towards the road as well, and that's what caused the initial flooding of the road, and which is causing the flooding at my property. So this is a picture of 21 Longwood Drive. The top picture is showing the new ponding area, which is essentially the trail that I use to get to my backyard. And in the top, you'll notice there's a large section of roof that has no gutter. Now, there's a very large square foot area that is, all the water off of that is coming right down the side of that building. It hits the ground, and then it will flow right under that fence into my yard. As you can see on the bottom, same map that the Lower Village Survey did, and they did elevation points on both properties. And as you can see by the green lines, where water flows, it is flowing down into my property. Here's some pictures. This is actually Longwood Drive in November, showing all the water runoff from 21 that caused the road to basically flood over. And then as we go clockwise, ponding in the shared ponding area. That area is almost always wet now. And the bottom left picture is actually showing the water running under the fence line onto my property. And then the bottom right picture is showing water ponding along the trail access that I use to get to the backyard. And these have all been sent to the town over the last few months. Starting in October, I sent them lots of emails, and they'll attest to that. But I would send them pictures, October, November, December, up until the CO was granted. Just telling them my concerns and what was going on the property. And the town engineer was also CC'd on all those emails. More pictures. This is a new ponding area, an area that never saw water on my property. Again, I understand we live in a wetlands, but there are areas of higher ground, and these areas, a bunch of them now are underwater. And as you can see, more ponding along the fence line throughout the different pictures. And you can also see the grade change along the fence in the middle left picture. From the fence down, it's 8 to 9 inches, so the water just runs down to the fence and then right down into my property. Okay, and switching gears. So, I'm going to go into the tree cutting violation. As I stated prior, these two lots, 17 and 21, have a large wetlands area that unfortunately was cut down. Planning board has seen this a number of times. So this whole area is all wetlands. And prior to the purchase of these two homes, this was all a really nice wooded area with lots of large trees. When Bob Santori bought the property, he had the entire property clear cut, which is illegal in a lot of different laws and codes in the state of Maine. So back to my list. So when this happened, Brian Paul, the CEO in this matter, sent Robert Santori a letter. Robert was in Florida, and I'm just going to read an excerpt from that letter. The act of cutting and removing trees, etc., in addition, removing the timber by heavy equipment, did occur in 2 wetland areas. These locations shown on a wetland delineation map prepared by James Logan of Longview Partners LLC, Environmental Permitting Specialist, dated 6/29/21, are priority number 3 wetlands and require a 25-foot no-cut buffer strip to be maintained around the wetland edge. So not only are you not allowed to cut down the wetlands, you're not supposed to cut within 25 feet of these wetlands. So what has been done is the forest that was a huge part of Longwood Drive and part of the community and neighborhood of that road was suddenly cut down and taken away from everyone that lived on that road. Everyone there before I got there enjoyed that part of the land. It was, full of nature, and it was a nice wetlands where lots of birds made their home. And then the letter goes on to say, this activity constitutes a violation of the local shoreland zone ordinance adopted by the town of Kennebunk on June 10th, 2009, Article number 10, Section number 3D, 2A, page 3, which regulates tree cutting and removal adjacent to and in a wetland. And then the letter goes on to say at the bottom, Leon Blood of Lower Village Survey, at your discretion, will conduct a field inspection of the wetland area for the purposes of determining the extent of leftover natural growth and prepare a restorative plan to be reviewed and approved by this office. So essentially, the wetlands need to be replanted by Mr. Centauri. So that was done by Leon Blood of Lower Village Survey. He inspected the lot, and he basically took the wetlands, split it up into grids to determine how many trees needed to be planted to make up for all the trees that were cut down. One thing that I noted is the wetlands do require a 25-foot no-cut buffer. There was no replanting plan based on this 25-foot no-cut buffer. So to actually replant this correctly, that should have been taken into account. It was in the letter sent by Brian to Robert Centauri, and that should be part of the planting plan, that the town mandates that Rob Centauri plants. So, a solution that was done by Leon Blood in this excerpt, essentially, and I'm going to read it from this. What this plan is showing is the red area, again, is the wetlands. It is saying that 88 trees need to be planted in a grid along these wetlands. And in actuality, only about 20 trees were planted. This second page.
I'm sorry, could you point us to the part of this document that refers to 88 trees being cut? Because
Yep.
I can't see it.
You see this little red square? 88 trees needed to be planted. So it's hard to read, but I have a bigger copy too. But it says 8 by 8 spacing of red maple whips, 88 trees to be planted. That's in this plan. There is another planting plan that asks for 96 plants to be replanted and had asked for 2-inch diameter plants. Those would have to be mechanically planted, so they are looking at alternatives. If to do it right, you would do the 2-inch diameter plants, mechanically plant them, then you'd have a forest. But another option was to plant these whips in a 8 by 8 grid. On this next slide, though, a key piece of information here, in that red highlighted area on that top image, says if several seasons and the amount of sprouting is not sufficient to reforest the wetland cut, then perhaps consider planting. And he says, perhaps an escrow account could be created to cover the cost of planting if deemed necessary. So what that is saying, and this is Leon Blood, who is a professional forester, that one of the alternatives, if you don't do anything, which is essentially what occurred here, that you need to give the area a few seasons of sprouting to see if it will come back on its own. And the issue with that is by then Bob Centauri would have sold these properties, and then he's not being held accountable for this. So Mr. Blood had recommended that an escrow account could be created, because if nothing grows there due to the entire change of the ecosystem, you know, it is in full sun now, where prior it was shaded, you know, it's different now. So things might not come back. There's also some worry that a lot of invasive plants that are all around that were not in this area but were in other areas of Longwood are actually populating the area, and they could basically grow up taller, bigger than these whips that are in there and the saplings that are below them, and choke out everything, and then we end up with just low growing weeds essentially. So what I'm hoping is we can actually make sure that this forest comes back, and I'll actually show you a movie of what this forest looked like prior. And like I said, it's an integral part of the neighborhood of Longwood Drive, and we got to make sure that we do not lose it. And this lower picture here is actually wording of that 8x8 grid spacing and the 88 trees that was, I believe, kind of like the final decision the town was going to go with. Again, asking for 88 whips, which are essentially tiny little saplings. You know, whether or not they take hold, we don't know that. The original design, the forester said, was like big 2-inch trees with huge balls to make sure they actually took. So these whips, again, 88 of them, had a good chance. Bob Centauri ended up planting 20. So there's a chance that none of them take. There's a chance that all those weeds I talked about take over the entire area, and we're left with just a weedy wetland instead of a forested wetland. Here's the third point that I had made in my appeal. This is very straightforward. Handrail is required. Now this is off the website. It says that a continuous handrail is required on both sides of stairs, except where a single-family dwelling unit with 3 or more risers is required at least on one side. So as you can see, oh, and then the 2015 IRC states that handrails are provided on not less than one side of each continuous run of treads or flight with 4 or more risers. As you can see, at 17 and 21 Longwood Drive, both exterior stair sets have 4 or more risers with no handrails. And this is just something I noticed, and because of everything else that was not accounted for, you know, I'm like, well, there's another thing. And this is a very typical thing that, you know, I never see a house that doesn't pass this. And to see it in my own backyard, I was like, there's an issue here. And as far as the CO that was given to both houses, there were no conditions of putting in a handrail for either one. So, in other words, the town has let this go by without citing it. So I have a letter here from a neighbor who was not able to be here but wanted her voice heard, and I figured I'd read that. And she actually addressed it to Chris, who is the town engineer. And throughout this, I haven't been the only voice to talk to the town about this. Pretty much all the neighbors along this part of Longwood Drive have been vocal, and again, we're at the planning board and wanted to make sure that the things that the planning board wanted to make sure did not happen, but they ended up happening. So it goes to say, this is Susan Hill, who is at 20 Longwood Drive, directly across the street from 17 and 21 Longwood. It says, "Hi Chris, I am currently out of town and cannot attend the public hearing this evening of the Kennebunk Zoning Board of Appeals. My focus in writing is the appeal of certificate of occupancy at 17 Longwood Drive and 21 Longwood Drive. My name is Susan Hill and I live at 20 Longwood Drive, directly across the street from both properties. I hope that the Town Code Enforcement Office will require implementation of gutters and railings in adherence to existing code. My primary concerns, though, are the drainage issues, made exponentially worse by the development of said properties and damage to the Priority 3 wetland by clear-cutting all of the trees at 17 and 21 Longwood Drive. As you know, the subdivision of these properties was vigorously debated before the planning board, and the abutters' major concerns were drainage management and potential damage to the wetlands. Despite assurances to the contrary, the outcome has been exactly what we had hoped to avoid. In my opinion, Mr. Santori should be required, even at this late date, to adhere to all conditions mandated by the planning board before building, to alleviate pooling issues. The total tree removal was particularly disappointing. My hope at this point is that a muscular approach to code enforcement will require that Mr. Santori reestablish trees in the barren wetland area. Instead of the cursory planting of 22 whips, this would mean strategically planting 2-inch trees described in Leon Blood's plan, 96 in all, as to achieve maximum survivability. I respectfully ask that you stand behind the conditions that the planning board stated were required before building permits were issued, and the remediation that the town require after the wetland tree removal. Thank you, Susan Hill." And this is an email that was actually sent to Brian Paul. This was back in June 3rd. And this was from Tyler Barter, who lives right across the street as well. And let's see. So, good morning, Brian. I am writing regarding the permit application and required a drainage plan for 17 Longwood Drive. I had a few minutes this morning and stopped by the town hall to look at the permit applications for the 2 houses. The receptionist was very helpful, thank you, and was able to locate the 2 permit applications and what was labeled as the drainage plan for 17 Longwood. When I reviewed the drawing, it appears that it is actually a driveway grading plan for the wetland crossing for 21 and had nothing to do with the other lot. The image below is from the drawing title block. When I returned the applications, I checked if there were other documents that were it. When the planning board was reviewing the proposed subdivision, there were a lot of concerns from adjacent landowners, myself included, about the impact of this development. Additional impervious areas and previously approved wetland fills on the stormwater that discharges from this site, across Longwood Drive to the wetland network behind our homes. The planning board agreed and added the requirement for a drainage plan that would demonstrate that this work will not impact our property with pre- and post-developmental stormwater calculations. What was submitted does not appear to address stormwater at all, and the drawing does not even mention the 17 Longwood parcel. Unless there are other documents that were not available this morning, I'm concerned that the requirements that we put in place as conditions of approval by the planning board are not being met. And with construction progress quickly on site, time to address this in a meaningful way is running short. And it goes on to say that he had an appointment with you next Thursday to discuss this, but I'm hoping that we can connect by phone earlier, as concrete will likely be in the ground before then. And that's Tyler Barter of 18 Longwood Drive.
Mr. Sevigny, these weren't part of your application, but are you asking for them to be included as
Yes.
part of your application? All right.
Yes, I am.
Could you make additional copies available to Ms. Winton? And
Yeah, I have copies here. I could also send a PDF email
Yep. Good.
After the meeting.
Thank you.
Actually, she might even have some of these already. So to go with what that I read from Tyler in June, he had gone to the town hall and looked in both folders for this grading and stormwater plan. And per the planning board, there was supposed to be a grading and stormwater plan for both sites. this is what was in the folder for 17 Longwood Drive. This is showing the driveway of 21 Longwood Drive. This is the only grading plan that is on file with the town. I myself went to the town, searched both folders. I've asked Frank and Brian to see the grading and drainage plan for both lots. This is all that was seen and approved. So it appears that the requirement from the planning board, I can jump back to that real quick. A grading and drainage plan be submitted, reviewed, and approved by the town engineer prior to the issuance of a building permit, with the intent that the development of this parcel will not adversely affect the surrounding neighborhood. So it appears that that was not met. Instead, there is just a driveway grading and stormwater plan for 21. This is an email from Brian Paul to myself back in May, and I was voicing my concerns back then about this grading and drainage plan and the issues I saw with the drainage. And he says, "Good afternoon. After several visits to the site and conferring with the property owner, the town has requested 2 reports, plans to be submitted for review. A proposed grading and drainage plan prepared by a licensed engineer, and a replanting plan for the wetland areas only that were harvested by mistake." And in this, he says that a Plan A was submitted, reviewed, and approved by the town engineer and myself. So I, again, have not seen this grading and drainage plan. This email states that they have seen it, reviewed it, and approved it, but I have not seen it, and neither has anyone else from the neighborhood. And no one from the code office or anyone from the town hall has been able to show me this grading and drainage plan. Okay. So this is essentially an elevation view of the grading and elevation marks that was done by Lower Village Survey, again in December 29th of 2022. It's essentially a cross-sectional view cutting through the new sites, showing the existing grade in green. And as you can see, the existing grade is sloping to the right. So just to go through this, on the left you see a line that says wetlands. This is on my property, everything to the left of this property line. I have a section of wetlands right here. About 7 feet from my wetlands is the property line. Now this 7 feet is essentially where my trail is that I've shown you pictures of to get to my backyard. To the right is 17 and 21 Longwood Drive. So in the existing grade prior to construction, based on the elevation marks that were done by Lower Village Survey, you can see that the water flows down to the wetlands along Longwood Drive. Those are the Class 3 wetlands that, again, were cut down, so they have their own issues, but at least the water was going down to those wetlands, again, prior to construction. After construction, based on, again, the elevation points provided by Lower Village Survey, you can see the house was built up quite a bit and a lot of fill was brought into the site. As you saw from the pictures, especially that first one I showed where it was just rough grading, the grading from the house goes directly down and onto the property line. Any water flowing off of this roof, which does not have a gutter, hits the ground and flows down to the lowest point that's closest to it. Good news on the front half is the water on this side flows as it originally did down to the wetlands. I don't have elevations of everything, but in the prior, there was areas that were flowing down into Longwood Drive. Those were remedied with a drainage ditch. I would like to know if that drainage ditch is actually adequate for the stormwater that's going to come off of that, and whether it was constructed in such a way that it will not just fill up with road debris and dirt, to prevent the road from flooding in the future. This right here is the full survey done by Lower Village Survey. It shows all the elevation points that they took and that I based all my images showing where water would be run and that cross section you just saw. Here is a picture of Longwood, 15 Longwood Drive, and then also 17 and 21. You can see here is a stake that is showing the property line. My trail runs right to the right of that stake. This is my crude little sketch, but it's just a visual to show that this was built up by a couple of feet, graded down, dumping water into my trail. That is everything I have currently.
We have a copy now.
Would you like? So, as I understand it, then there are 5 exhibits essentially that you'd like to make part of your application.
Yes.
The 2 emails, which will, if you can mark those as hearing exhibit 1 and 2.
Which ones?
The 2 emails that you referred to.
So the one from Sue will be number 1. The one from Tyler will be number 2.
Right, then there was your own elevation plan that you had prepared showing the original elevation and the new elevations.
Yeah, they're cross-sectional.
That'll be number 4.
What's number 3?
Oh, so the 2 emails are 1 and 2, and number 3 is the graphic, and the elevation plan is the plan that was prepared by Longview, upon which your graphic was based, right?
Big.
Yeah.
I thought it's included that, but maybe not. Okay, this guy. What do you want this one to be?
Number 4, and then 5 of the composite exhibit of photographs that you showed of the trees.
You guys just want hard copies, and I can follow up with an email?
Yes. All right, Mr. Sefney, are there any other documents that you wish to introduce into evidence?
As long as you have all the ones that I just showed, I'm good.
Are there any additional witnesses that you would like to call?
I would say anyone that's here that would like to speak?
Well, we'll have there'll be a public
Then that.
comment. All right, so,
Should I give these to?
Ms. Winton, please. Thank you.
Mr. Chairman, can I just ask that the screen stop being shared just because? Unless the.
Yep, I can unshare.
All right, I think what we ought to do here is to have Mr. Kunkel's representative make the presentation from the code enforcement officer, and then we'll have any questions from the board here, and then we'll open it for any public comments that the members of the public who are in attendance wish to make. Is that acceptable? Ms. Rachin, is that okay with you? All right. All right. I guess, Mr. McCall, you're going to make the presentation on behalf of Mr. Kunkel?
I think this is on. Is it? It's on? Okay, great. Good evening, members of the board. Ms. Rachin, good to see you. Unfortunately, I'm sorry you're not feeling well. My name is Ben McCall. I'm an attorney at...
A little closer to your mouth, please.
Oh, of course. Is that better? Okay. My name is Ben McCall. I'm an attorney at Jensen Baird in Portland. I'm one of the town attorneys. I'm here representing both of the code officers. I suppose the code enforcement office is the best title. I want to focus on a rather dry legal topic, which is procedure, and I think it's been outlined generally in the letter that I submitted to the board, but I don't want that that procedure to get lost in all of the issues that are going around, and there are quite a few that have been presented. First of all, I think it's worth noting that the code office absolutely doesn't dispute the presence of stormwater problems in the Longwood Drive neighborhood. Those were certainly at top of mind for the planning board back in 2021 when it was reviewing Mr. Santori's original subdivision approval application, which was approved with the one condition of approval that Mr. Seveny has noted throughout his presentation. We're also not disputing the fact, and certainly this is something that the town is still working with Mr. Santori on. We're not disputing the fact that there were trees illegally cut on the property. I think that's a separate violation, and I'll touch upon it a little bit later. We're also not disputing the fact that there are problems with handrails on the two houses in question that are being addressed at the time being. But unfortunately, what's before you tonight is an appeal of two certificates of occupancy that were issued following the previous issuance of building permits for two single-family homes. And because of that, I think it's worth reiterating the fact that when you're reviewing appeals from the issuances of certificates of occupancy, the Board of Appeals' role and review is extremely limited. And as we outlined in our letter, Maine law is clear on this point that what you are tasked with looking at are not the underlying conditions of the neighborhood. They're certainly not private issues relating to stormwater and the like, but it's the simple question of whether the house that was constructed in this case meaningfully exceeded, and that's the term of art used by the Maine Supreme Judicial Court, the authority that was conferred on it by the building permit. And again, the town, we don't want to lose sight necessarily of the underlying stormwater issues. We're not debating the fact that they are significant to Mr. Seveny, but they're also outside the scope of what this board is tasked with reviewing tonight. So I want to talk a little bit first about how we got here with regards to stormwater, and then I'll touch upon the two other issues that were raised in the appeal. So as I mentioned before, 17 and 21 Longwood were originally one lot. Those were subdivided pursuant to a subdivision approval that the planning board issued in 2021. And as Mr. Seveny points out in his appeal, that planning board approval did contain a specific condition of approval that said a grading and drainage plan needed to be submitted, reviewed, and approved by the town engineer prior to building permits for both of those houses being issued. And in the opinion of the town engineer, after those plans and specs were reviewed, the town engineer was of the opinion that to the extent it could be alleviated, that additional stormwater issues would be prevented by the construction of these houses in compliance with those stormwater and drainage plans. So building permits were
Just to interrupt you for a second, where is that plan?
So what we do know is that there is a plan that was issued for 21, and that did contain some information about 17. That composite plan, if you will, was deemed sufficient by the town engineer when building permits were issued for both houses. So when that occurred, when those building permits were issued, there is always, as with any other decision of the town, a period when an abutter, a person with a personal interest, could appeal the issuance of both of those building permits to this board. And I think it's important to note that that didn't happen at the time that those were issued. So the building permits were issued and construction ensued. And I think it's important also to point out, and both Frank and Brian are here if you have specific questions on this procedure, but I think it's important to note that during the construction of the home, the code office performs multiple inspections and multiple site visits over the course of construction, and issues multiple permits along the way for certain aspects of that construction. So for instance, an inspection is done prior to the blessing, so to speak, of the foundation of the house. A separate inspection is done after the footing is installed. Another one for the framing, another for the insulation, and then another for the electric. And this is just to name a few. There are additional inspections and checks, so to speak, that go into the process of building a home. And not once during those inspections did Brian or Frank find any particular issues with the construction of the homes in a way that indicated that they were not being built to code or not being built in a way that was compliant with the subdivision approval issued by the planning board. And so we get to this point in time where the homes have been completed, and as is the case with any other construction in Kennebunk or elsewhere in Maine, there is a final inspection, and that final inspection is truly meant to check on one issue, and again, that's whether the building in question has been built in compliance with the applicable codes and laws of the state. And so in particular here, it's the IRC, the International Residential Code, that applies to single-family homes. At the time that the CO inspection occurred, there were no issues noted by the code officer, which hence why the certificate of occupancy was issued. Now, as to the issue of handrails.
Just to focus your attention on the grading and drainage plan, it seems to be a fairly central document here, and it's certainly referred to in the findings of fact and conditions of approval, but it looks to me from the documents attached to the application here as if that grading and drainage plan is particular to 15 Longwood Drive. I'm not an expert in this.
No,
I'm
not
just
at
trying
all.
to
Well,
piece together the various approvals. But looking at the documents attached to the application here, it looks like the grading and drainage plan has to be submitted in connection with 15 Longwood Drive. Is there anything that requires a grading and drainage plan to be submitted in connection with Lot 17 and Lot 21?
So it as part of, and Brian and Frank can both correct me if I'm wrong in this part, but when you have conjoined lots like this, it's often the case that if there's a previously existing grading and drainage plan for an adjoining lot, because the stormwater runoff will generally affect surrounding lots, that can be used. And again, it's in the discretion of the town engineer to look at a grading and drainage plan which may have been prepared for a different lot.
Now, I'm looking at the findings of fact and conditions of approval, and here's what it says. A grading and drainage plan be submitted, not older ones. A new one has to be submitted, and then it has to be reviewed and approved by the town engineer prior to the issuance of a building permit.
Correct.
Well, was one with respect to Lots 17 and 21?
So in the opinion of the town engineer, there was sufficient documentation to show that sufficient grading and drainage had been demonstrated in order to meet that condition of approval. So yes, in the town engineer's opinion, that had been met.
Okay. So let me just ask you, well, to the extent that there's a requirement for a grading and drainage plan, it looks to me like from the material that's been submitted in connection with this application, that only applies to Lot 15. It doesn't apply to Lot 17 and 21, is that correct?
Brian can elaborate on that point.
On, yep. Initially, the planning board looked at the subdivision of this piece of property as 15 Longwood. Okay, in the initial submission that says a drainage and grading plan will be submitted and reviewed by the town engineer prior to the issuance of the permit, with the intent that the development of this parcel will not adversely affect the surrounding neighborhood. That drainage and grading plan was submitted by registered design professional John Ogier, and it was reviewed by the town engineer, myself, and Mr. Santori on April 4th. The thinking at the time was because of the flatness and the elevation lay of 17, that if in fact it was required at a later date, an as-built could be performed on that specific lot to address any grading and draining issues. But at that time, we didn't feel as though there was one that needed to be required for 17.
Right.
Mr. Chairman, can I just ask a quick question if it's appropriate?
It's always appropriate.
Thank you. So I understand that there are so many issues swirling around here, and I'm just trying to make sure that we are staying on track. And so I am actually hoping that Attorney Katsiafikis can help with this one issue. I understand that there is concern, and I myself had some concern around whether or not there were those drainage plans that were submitted consistent with the condition of approval. But if I understand correctly, that was a condition before a building permit could be issued. And here, that ship has sailed, as I understand it, is from a timeliness standpoint. We're dealing with a certificate of occupancy, which is much later in time than the building permit itself. So had there not been that drainage plan submitted, that would have been a reason to deny the building permit. But I guess I'm looking to Attorney Katsiafikis to help clarify sort of our lanes that we need to stay in and the timeliness factor that we're talking about here.
If I may?
Absolutely.
Thank
Please.
you. An important consideration here is the scope of the ability to appeal a certificate of occupancy. As Attorney McCall pointed out, there's a limited window for these appeals, and it has to be with something that is the subject of the approval itself of the building, the building exceeds the lawful permit. It cannot be used as a way to substitute for an appeal from the earlier decisions. It can't be used as a substitute for a failure to appeal from the planning board approval, subdivision approval on the stormwater plan, for example, or for a failure to appeal from the issuance of the building permit. And to the extent that's what's going on here, that's not before the board. The board shouldn't be using this as a way to relitigate the building permit. That ship has sailed. The building permit issued. There's a 30-day appeal period. No appeal was filed. That's done. And so the question is there something in the construction that violated the permit? For example, the handrails. Perhaps that's an opportunity and a reason to modify the approval and to reissue a building permit with a certificate of occupancy with the condition that the handrails be improved. But it's not an opportunity to go back and relitigate the subdivision approval, stormwater plan, or to relitigate the building permit with regard to the drainage plan. Those events have happened. The appeal periods have passed. That's not for the Board of Appeals this evening.
Microphone, Ms. Rachin. Leah.
Am I here? I'm sorry, I apologize. Can you hear me now?
We can hear you now, yes.
Okay, sorry, this is along the same lines of kind of making sure that we, as the Board of Appeals, are staying within our lane and only exercising that authority that we have been specifically granted. I have heard a lot about the unlawful cutting and the frustrations around that, understandably so, and the fact that, you know, there's an outstanding violation. I'm not sure what the status is of that. But once again, I'm looking for guidance from Attorney Katsiafikis as to how much, if at all, that can factor into our decision-making process. It's my understanding that enforcement matters are outside the jurisdiction of this board. That's something that the code office, in conjunction with the Board of Selectmen, make decisions about, and what to enforce and how to do that. And as frustrating and understandably so as that may be for Mr. Seveny and his neighbors, I'm wondering, Attorney Katsiafikis, if you can please address whether or not that can or should or can factor into our decision-making process.
Certainly. With regard to enforcement, that's a matter for the code enforcement officer, and then it is beyond that up to the town as to whether this, through the select board, as to whether it wants to initiate litigation in order to conduct an enforcement operation. So there isn't an enforcement decision that's in front of this board. There's a question as to whether the town is following through on plans, but there is a resolution that's being worked out. It's within the town's discretion as to how and in what manner it will enforce ordinance violations. It's not up to the Board of Appeals. The Board of Appeals doesn't have a role in actual enforcement of the ordinance. Its role is to hear appeals from the decisions of the code enforcement officer.
If I might just interrupt you
Absolutely,
there.
please.
Looking at Article 6, Section 2A, dealing with administrative appeals and the rules that we have to follow as a zoning board of appeals, it says, to hear and decide administrative appeals where it is alleged that there is an error in any order, decision, or ruling made by the code enforcement officer in the enforcement of this ordinance. So matters of enforcement do seem to be within the purview of the zoning board of appeals.
There are times when a code enforcement officer may issue an enforcement order to, for example, the developer here. And the developer may appeal that order. That's not before this board. This is instead a complaint, and I understand the reasons, but it's a complaint by a neighbor that the town's chosen resolution is not enough to satisfy the need presented by the alleged violation. That's a totally different matter. How this violation gets resolved is up to the code office, and it's up to the select board. And they are working on it. There's no role for this board in second-guessing how that's done.
So, Mr. Chairman, if I might clarify, if I hear you correctly, Attorney Katsiafikis, this notion of an administrative appeal of a code enforcement officer's enforcement decision, that in that case, the developer could have appealed that enforcement decision, right? That notice of violation. But here, what we are tasked with is the administrative appeal of the certificate of occupancy, right?
That's correct, which does not involve the enforcement action.
Thank you.
And in that regard, I must say, looking at the legal authorities that you cited, Mr. McCall, specifically the Tomasino decision, the Supreme Court has consistently emphasized that municipal zoning cases are not the proper forum for a private property dispute between neighbors, right? And in that case, a private property dispute was precisely what was before the board, correct? And isn't that what we have here, essentially?
I agree with you, Mr. Chair, that to a great extent, my understanding of what's precipitated this appeal are ongoing issues surrounding stormwater from one private property owner vis-a-vis another private property owner. And I agree with Mr. Seveny completely that there is a provision in Title 17 of the Maine Revised Statutes that does regard private nuisances that could be created potentially by the unlawful diversion of stormwater from one private property owner to another. And whether or not Mr. Seveny and Mr. Santori feel that the issue is severe enough to lead to private litigation or dispute resolution is between them. But I agree with Attorney Katsifikas completely that that for better or worse, what is before the board tonight is only the issue of whether or not the houses that were built complied with the building permits, because after the planning board issued its subdivision approval, there was no appeal taken from that approval, and likewise no appeal taken from the issuance of building permits. So I think as to the stormwater, as Brian has explained, the town engineer was satisfied prior to the issuance of building permits that the condition of approval had been satisfied. And that decision wasn't appealed and is not before the board tonight. And I think that any further issues related to stormwater, which may well persist, given the fact that this is a wetland and was certainly a boggy and wet area prior to any construction, could be the subject of litigation between private parties, but again, does not involve the town and doesn't involve the town's Board of Appeals. With regards to the vegetation, again, I don't want, Attorney Katsifikas, I think, summed it up completely, and we made the point in our letter as well. The resolution of that notice of violation regarding unlawful cutting in the shoreland area is still ongoing. There certainly was a proposal early on for the number of trees that may be adequate to solve that, but that process continues. And I completely agree that the issuance of the notice of violation could have been appealed by Mr. Santori, but that's completely outside of what this board is looking at. And to the extent that the town in the future decides to take enforcement action in district court with regard to this case, that is also, that's between the code enforcement officer and the select board, and a decision for them to make. And then finally, I agree also, and I hate to say that I'm agreeing over and over again, but I think the one issue that's been presented in this appeal that is within the scope of this board's review is the issue of the handrails. Traditionally, and I believe this is the practice for many code offices throughout the state, if a minor issue like the presence of, or the lack of a presence of a handrail is discovered when a final certificate of occupancy inspection is undergoing, the C of O could be withheld until the issue is fixed, but more often than not, small issues like that are added as conditions to the issuance of that CO. So put another way, we will grant you the certificate of occupancy provided that you install a handrail that's code compliant within a certain amount of time. And again, not to belabor the point, but if that didn't occur, that would be grounds for the code office to either revoke the C of O, to issue a stop work order, or other enforcement action. My understanding from the property owner and through the code office is that this particular issue is being resolved as we speak, not literally as we speak, but is ongoing. The town doesn't have any objection, I would note, to the board tonight issuing a decision that specifically adds that as a condition of approval to the certificate of occupancy. That typically would be done in this process, but it was not done here. So I think.
Mr. Chairman, do you mind if I ask Attorney Katsifikas a question in that regard?
No.
So I understand under our authority in Article 6, talking about what we may do as a board, and I think the words are, three magic words are affirm, reverse, or modify. In the case of a situation where we decide that it was an error to issue that certificate of occupancy absent those handrails, would it be within our purview to add a condition of approval that requires that it be done by a date certain, and would that fall within the auspices of modify the CEO's decision?
My advice is yes, that could be within the auspices of the idea of a modification, and you might ask the CEO to add the condition or to reissue it with a condition, whichever is the cleaner way.
And if, in fact, Mr. Santori does not abide by that, that then becomes yet another enforcement action?
Entrusted
Or-
to the discretion of the town, yes, for
Okay.
enforcement.
Thank you.
So at that point, Mr. Chair, I'm happy to answer any further questions that the board may have. But I think in conclusion, again, the town is not trying to dismiss the legitimate concerns about stormwater in the neighborhood. I think they're present. I think they're real. But I think, again, this board's review and purview tonight is extremely limited. And again, only to the simple question of whether the homes that were constructed complied with those building permits. And I think with the sole exception of the handrail issue, all of the issues that have been presented as part of Mr. Seveni's appeal are either untimely, if they are with regards to potential deficiencies in the building permits that were issued, or are simply outside the scope of the decision that has actually been appealed, which is the certificate of occupancy. So issues regarding cutting and the like, again, are a separate enforcement matter to be dealt with separately. So if the board has no further questions, I thank you for your time.
Mr. Berry, do you have any questions?
Not at this time. I'm still trying to put the timeline together here. So just to clarify for the timeline, whenever the re-subdivision of the lot was done, the timeline that anyone could appeal passed. The timeline that the building permits were issued, which was May 31st, 2022, no appeals were filed, so that timeline has passed. So the only one that seems to apply timeline-wise, and that's what I'm working on right now, is the certificate of occupancies were issued January 11th, 2023, and the town received the appeal February 8th, 2023. Is that correct on all those dates? for
Absolutely.
Everyone?
Absolutely,
Just so I
Mr.
have the
Berry,
timeline.
yes.
So it seems like the only appeal that we can work on is the one that was received February 8th.
Correct.
Is that where we are right now?
Yes,
At least from a timeline point of view?
Yes, it's
Okay.
only the certificates of occupancy, and again, as Attorney Katsifikas pointed out, the Maine Supreme Court has said over and over again that appeals of certificates of occupancy cannot take the place of appeals of issuances of building permits.
I'm
And
just looking
Yep.
at the dates here. That's I'm
yes,
just wondering,
it's just the
trying
season.
to clarify, which are the valid layers of appeal that we can look at? The only one I can see right now is the CO.
That's all that's before the board at this time.
Yes.
Okay. Thank you.
Thank you. Ms. Rachin, do you have any further questions?
Thank you.
Thank you. I guess we're at the point where any members... Yes, sir, please do.
Okay, thank you. All right. So, as far as what the attorney said, I just want to point out a few things. That at no point during these in the second page, when the CEO goes out on occasion to look at the property, he says that at no point during these inspections did the CEO notice any material deviation from the approved building permits or any other code issues that require correction. I would have to disagree with that. For one, the handrail, that definitely deviated from code. The other more major thing is that on one occasion, and I know they went out there, is the road was flooded. It went across the road, and this was caused by, again, the drainage issue that the planning board was worried about. And because of this, the CEOs, made him put in a drainage ditch to correct this issue. The problem is will this drainage ditch actually fix this issue? There was no stormwater drainage plan made as the planning board had required. So because of this drainage ditch may just fill in, the road will continue flooding. So as far as the building permit goes, and the case that the lawyer brought up, his point was that an abutting property owner may only challenge whether the permittee has meaningfully exceeded the authority contained in the building permit or otherwise violated conditions of the permit. Now, I would disagree that we're only talking about the CO, because what has occurred is there are violations of the permit, of the building permit itself. The conditions set forth by the planning board for the permit, for the building permit, was to have a drainage and stormwater plan. If you look at the documentation the lawyer provided, the building permit number 2918, the conditions were set on this permit as approved by the Kennebunk Planning Board Subdivision Amended Plan. So that tells me that there is a condition set on this building permit. Therefore, the drainage issues and the stormwater issues are relevant and can be decided upon by this board. The other point that the lawyer made was that this is an issue between two parties, two neighbors, just along a border. And it's much more than that. It's not only my property, it is Longwood Drive. And the water is not only dumping onto my property, it is also dumping into Longwood Drive. So as the planning board had made as a condition, is that they wanted to see a stormwater plan. Whenever you take an area that is sloped down to a wetland and you build up on it, as my cross-sectional view showed, water is going to go off in different directions than it normally does. The reason why everyone was so concerned is because those areas which in the past had not received water are now receiving water, as we've seen by the pictures that I've shown. And it is not, again, just a neighbor issue. It is the entire neighborhood of Longwood. And then as far as the, Hurl versus Town of Waterboro, the lawyer made a note that private citizens do not have the authority to initiate land use enforcement proceedings. I did find that if a municipality refuses to bring enforcement action because it believes that its ordinance has not been violated, we permit a neighbor to challenge that legally, as distinguished in determination in Richard versus City of Portland. It was a successful appeal from a city's refusal to bring an enforcement action because of the mistaken belief that the ordinance was not being violated. And it also occurred in Toussaint versus Town of Harpswell. So those are two examples where the town did not enforce an issue that a neighbor, a town, someone from the town brought up and was like, hey, this needs to be enforced. An entire neighborhood is saying this needs to be enforced. So, and also, a quick thing on the handrail thing. He noted that the CEO would have noted that it as a minor correction on the condition of approval, and there were no conditions of approval for the CO. So it was not part of it at all. In his conclusion, he did state that it is the planning board, basically stormwater management is an important consideration of the development of property, particularly in neighborhoods like Longwood Drive, where flooding has previously occurred. And in order to avert such issues to the greatest practical extent, the planning board directly reviews issues pertinent to stormwater management as part of its approval of subdivision and site plans. He says that this occurred prior to the development of 1720 and 21 Longwood Drive and resulted in a stormwater management plan being submitted to and approved by the town engineer. again, there was never ever a stormwater and drainage and grading plan prior to the building permit and CO. And as the building permit stated, there was a condition that the planning board's plan needed to be followed. So, that's my rebuttal.
I have a question on the two cases that you cited.
Yes,
Do you have copies of those?
I do not have the full copy of the case. I could get them.
Could you give those to Mr. Katsifikas so that he could refer to those? But my question,
Give
I
them the
guess,
names
is
of them?
the cases and the
Yeah.
names, yeah. Yeah. You should have brought copies.
Yeah, hindsight.
Mr. Katsifikas, what he's referring to in those cases, for the limited amount of information that he gave, it doesn't reflect on this board. Those cases don't reflect on this board, do they? Aren't they really to the entity of the town and not to this particular Board of Appeals?
It would be a complaint about non-enforcement by the town, which is not what was in front of you. What's in front of you is an appeal from a certificate of occupancy. So I will certainly take a look at those cases and report back since they've been raised. But it doesn't sound like they're directly on point, given the proceedings here.
Okay, now, just to clear up here, there are three points here that Mr. Seveny brought. You have opined that the first two don't apply.
Correct.
This board has not decided on that or not yet, right? All you're saying is there are three parts, and you're focusing on those three parts, but.
Right.
But should this board at some point move to decide which of the three, if any or all, we can decide on, or?
There's a three-part appeal, basically, in this certificate of occupancy appeal. The first part being the drainage, and the second part being the trees removal, and the third part being the stairway, the railings. With regard to the drainage plan, then the stormwater issues, the flooding issues, all of that really point toward the planning board approval of subdivision. And with the grading plan, the issuance of the building permit. Both of those things have already happened, cannot be appealed at this time, and they're not within your jurisdiction. You have jurisdiction to hear certificate of occupancy appeals, but you can't act on this one because it's really trying to go back to things that have been decided. That's my advice. The second point with regard to the trees, that is entrusted to the discretion of the municipality as to how to enforce. Enforcement action is ongoing, and you don't have a role in that ongoing resolution of an enforcement matter. The third prong, you do have an ability to address it, and that would be if you believe that there was an error here in not attaching a condition of approval with regard to the railing, the handrail, then either you can modify the code enforcement officer's issuance of that certificate of occupancy and ask either that a condition be added or issue a new certificate of occupancy with that condition on it. But the condition would set out how long the person has to install that handrail. That's my advice with regard to the three facets of this appeal. A suggestion, if you agree with that direction, and you still have to hear from the public, if you agree with that direction, you could ask me to prepare a draft decision and bring that back to you. Send it to all parties in advance and say maybe in 2 weeks or whenever you want to get back together again to take a look at this. Perhaps that's one way to resolve that.
Can I ask a question or make a point?
Of course.
So as far as your recommendation, is that taking into account the condition from the building permit that said it has to follow the approved Kennebunk Planning Board subdivision amended plan?
Well, yes, it was a condition of approval. It's been followed in the sense of the drainage plan was submitted. It was approved by the town engineer, and the building permit issued.
But a drainage and stormwater plan was never submitted. That's one of the major things here. Even though there is a condition here, and the condition is that the building of this house needs to follow the planning board's rules. And if they're not following the rules,
I understand, but
it's not saying the building permit, I'm not saying,
well,
I'm going against that, I'm going against the CO because it's not following what was in the building permit as a condition, which,
that,
I didn't mean to interrupt, Mr. Seveny, please finish your thought.
which is what the law states according to both lawyers here today. That as long as we're saying that as a condition of the building permit, we can appeal that.
there was an opportunity to appeal whether the appropriate plan had been submitted in order to get that building permit. And it was at the time that the building permit issued. No appeal was, go ahead.
Just clarify that, because again, you know, I always go back to our rules and what they say. And so my understanding of the case law from what we've heard today, and also just my own understanding of it, is that the courts are reluctant to allow anyone to basically bootstrap what would be an untimely appeal of a building permit by trying to get at that building permit by appealing a later certificate of occupancy. And if we go back to our authority and what we're supposed to do, if we look at, I think it's Article 6 of the town's zoning ordinance, it talks about what the appeal procedure is. And if there's any person who's aggrieved of a decision of a code enforcement officer, here, the building permit, which was issued in May, they must, and it's shall, the language is shall, commence his appeal within 30 days after issuance of a written decision from the code enforcement officer. So in this case, if, and I think we're saying the same thing, but just to reiterate it, if there was an objection to the issuance of the building permit because that drainage plan or a sufficient drainage plan was not presented to the town engineer, which was the condition, if that was not done, then the time to appeal that building permit was within 30 days of issuance in May of 2022. That was not done. So as I understand the case law that you have explained to us, that in essence, you cannot try to get back in time an untimely appeal of what should have been an appeal of the building permit by doing it through the occupancy permit. Is that fair? Is that a fair understanding of where we're at?
That would be my understanding. And the idea of saying that you have to comply with the planning board approval as a condition of issuance of the certificate of occupancy, that doesn't reopen things. It doesn't bring you back. That would be my advice.
Because that condition was really on the building permit, correct?
Correct. And it was satisfied or not satisfied at that time, and people had their rights to appeal.
And isn't it the case in Kennebunk, unlike many other municipalities, that they actually send out those green cards to say, hey, building permit has been issued, come on in and have a look, and if you've got an issue, that gives them that 30-day period to appeal. I could be wrong in that.
we never got one.
But are they posted and are they sent out as a matter of course? Okay.
One more point to go along with that. So yes, a drainage and grading plan was supposedly to be submitted, but not only that, but the development of this parcel will not adversely affect the surrounding neighborhood. That is also a condition. And that can or should have been looked at by the CEOs looking at this and seeing it with their own eyes that the neighborhood was adversely being affected, and yet they still gave the CO. And it's written twice.
One question for you, Mr. Sevigny. Quite apart from the technicalities of appeal periods and appeals from building permits and certificates of occupancy, you could have brought private litigation against Mr. Centauri or his company to abate the nuisance, correct?
That is an avenue I could take, yes.
Have you done so?
No, that is a very expensive avenue to take. And I, living in this town, have faith in this town and the code enforcers to protect the neighborhood, my home, my neighbors' homes, and to go by, what the planning board had decided. I brought this up, back in May, after all the trees were cut and the grading started, and thought that, pictures and emails would have the town watching out for this and wanted to make sure that the best job was done for the neighborhood so that we did not suffer any adverse effects as everyone worried about. Unfortunately, all those have come to fruition. So again, I haven't gone the legal route. I'm trying to go, through the codes, through the steps that are in front of me, and there are some technicalities and there's cases that were decided beforehand that really aren't apples to apples with this case, but they were decided. But with everything, there are ways to interpret these codes, and it, very simply states that if there's violation conditions of the permit, that it can be appealed. And, the town of Kennebunk should want to do the best for their citizens, their tax-paying citizens that are just trying to live. And, we're looking forward to the new neighbors moving in. But if their homes are having drainage issues with their neighbors, anyone Bob Centauri sells to potentially could have legal issues in the future. It's going to erode my land to the point where I won't be able to walk to my backyard without going through wetlands, So, I guess that's the long answer.
Do any of the other board members have any other questions at this time? All right, well, thank you very much, Mr. Sevigny. I guess at this point in public hearing, we'll just open up the floor to anybody who wants to have some input on these issues. When you come up, make sure that the microphone is activated, and please identify yourself and state your address, please.
Thank you. My name is Matt Williams, I'm the attorney for the property owner. I'm an attorney with Hodgson and Air here in Kennebunk. I do want to point out kind of a little housekeeping issue.
Which property owner are you referring to?
The property owner of 21 Longwood Drive and 17 Longwood Drive.
Okay, and that is?
Well, let me get to it. I do want to point out a housekeeping issue here. The property owner is identified in the appeal application as Bob Centauri. That actually isn't the case. My client is the Centauri Group, LLC, which is the correct name of the owner of the property. So I do think that bears some consideration if the board is going to be looking at this. I can provide a copy of the deed to the property that was not included in the appeal if the board would like me to do that, Mr. Chairman.
Think that that's necessary, but I'd like to hear from my fellow board members on that. And the reason is I don't think the Centauri Group or Mr. Centauri are a party to this appeal. It's really the code enforcement officer who's the party on the other side, and Mr. Sevigny is the individual appellant.
My client would be most certainly adversely affected in this matter, and if there were to be any sort of an ADB appeal or anything of a decision of this board, my client would most certainly be involved. So I do think, for the record, it is of some importance that my client is correctly identified as the actual owner of the property here, and that I'm identified as the counsel for my client and participating in this proceeding as well.
Mr. Chairman, for my part, as a board member, I have no objection to that being received into the record. It's, we're having a public hearing. You've got somebody who represents a party in interest, and as far as just entering it into the record, I don't have a problem with that. But of course, I would ask Attorney Katsifikas to weigh in on that piece.
There's no harm in accepting it as part of the record, and it verifies what the name is of the entity, so that's fine.
Certainly.
Mr. Berry?
I have no objection to it being submitted.
I have no objection either.
Thank you.
Excuse me, could you again stipulate what those submissions are?
That's just a copy of the deed from the prior owner of the property, Sheila O'Donnell, to my client, the Centauri Group LLC.
For which lot?
Both.
Okay, so you submitted
One
copies for-
deed, and there's two properties on
one
that
deed for
deed.
two properties?
Correct.
Okay,
If you
yeah.
look at the deed references both 17 and 21 Longwood.
Thank you.
Just to make things clear. As for the legal positions that have been reiterated here to the board, much like Attorney McCall, I do a lot of agreeing. And I agree that with regards to the drainage issue and the enforcement issues, I don't believe the ZBA has the jurisdiction to hear those issues with respect or as they apply to the appeal of a certificate of occupancy. I guess we'll punt or whatever on the handrail issue, in the sense that my client is taking care of the handrail issue. That's expected to be taken care of in a week, so it does not make a large difference from our perspective if the certificate of occupancies are modified in any way to reflect that as a condition. With regards to some other issues that Mr. Stephanie had brought up, I noted he was trying to make some hay with regards to the fact that the building permit list conditions saying as approved by the Kennebunk Planning Board. As to the drainage issue, as the ZBA's attorney has pointed out, the drainage plan was to be submitted before the building permits issued. So to the extent that Mr. Stephanie found that deficient, his time to appeal would have been at the time of the building permit. I'll further point out, though, that in the evidence he did submit to the board, there's also a email, I believe, dated May 9th, 2022 from Mr. Stephanie. I don't have it in front of me because I wasn't provided with those documentary pieces of evidence. However, that does show in that May 9th, 2022 email, Mr. Stephanie quibbling with, I believe it's with the code office, it might be with Mr. Osterreiter, with regards to the sufficiency of the drainage plan or where the drainage plan was. My point being is that to the extent that someone were to argue as to whether or not somebody had notice of what was going on, I think Mr. Stephanie had more than adequate notice. I have reviewed correspondence with regards to these building projects, and I do know that Mr. Stephanie was, to say he was in frequent contact with the town would be the understatement of the year. So I do know that he was keeping close tabs with regards to what exactly was happening on that property or on those two properties. I do also want to, I don't want to get too far into the substantive nature of his appeal because, again, I do not think the board has jurisdiction to hear those issues. But I do want to at least note and ask if the board will take into evidence. I have the deed to Mr. Stephanie and his wife, Laura, dated January 14th, 2022. I also have a copy of an occupancy agreement between Mr. Stephanie and the prior owner, which shows that Mr. Stephanie did not occupy the property until March 11th of 2022. And again, I feel like I don't necessarily want to get into the substantive nature of his appeal with regards to the drainage issue, but I also can't help but comment on this. I did see a lot of testimony with regards to the path he used to use and his knowledge of the history and he didn't live there until March of 2022 after construction already started. So I do find it fantastical that he can testify as to his knowledge as to what went on there beforehand. So if the board will allow me to submit these two, this deed and the occupancy agreement showing when he actually did occupy the property, Mr. Chairman.
I'd like to solicit my fellow board members' views on the admission of those additional exhibits.
It seems to be irrelevant, given your previous position that we're not going to be ruling on 1 and 2.
Well, if you had made that ruling, right? So there's an issue too, and this is sort of a procedural issue I do have. It seems interesting that we've allowed the substantive discussion of these drainage and enforcement issues to continue. The reason being is if there is no jurisdiction to hear those issues, I guess, then what are we doing? Or what is the board doing, listening to them to the extent they are? And that's sort of the issue I'm in. If the board has already said, yeah, there is no jurisdiction to hear those issues, then you are entirely correct, Mr. Berry. It would be irrelevant. But since I actually haven't seen the board decide that yet, and they haven't necessarily indicated how they are, that's kind of the issue I'm looking at. I don't know if Mr. Katsvikis can...
If I may jump in for just a moment, the board has jurisdiction to hear appeals from decisions of the code enforcement officer, which would include the jurisdiction to hear appeals from certificates of occupancy, but the scope of that is limited to those matters that are from the actual appeals. Is there a violation of the permit? And the board might think that the first two arguments are not within that. And so they have jurisdiction to hear the certificate of occupancy appeal, but not to decide this one because of what's being argued.
That's...
But Attorney, I take the point that we haven't ruled on that yet. And so to the extent that we have not, and we have accepted quite a bit of evidence about the drainage issues and such, I think it's important that we at least accept it into the record, and then we can make any determinations on relevance once we've made those, threshold decisions.
Then I guess we will accept the additional exhibits that you want to introduce into the record without any concession as to their relevance.
Thank you, Mr. Chairman.
No, I think these would be Centauri Group exhibits, starting with, yes. Yes.
Yes.
Could you identify all three of those for us, please, for the record?
Are you asking me, or are you asking her?
I'm asking,
Okay.
Ms. Whitten.
Okay, I've accepted the warranty deed as hearing exhibit number 1 from the Centauri Group. I have also just accepted another warranty deed, hearing exhibit number 2 from the Centauri Group. How would you like me to distinguish those?
Maybe by date?
Okay, hearing exhibit 1, December 30, 2021. Hearing exhibit 2, January 14, 2022. And hearing exhibit 3, the Centauri Group, is titled Occupancy Agreement.
Of the same date?
14 January, though there is a spelling error in the word January 2022.
Thank you.
That is basically all I have for the board. Thank you for your time tonight. Does the board have any questions for me?
The chair does not.
Just to clarify, you had cited a particular email, but you said you didn't have a copy of it?
No, I didn't. I saw it flashed on the screen when I was sitting there, and I wrote it down. I scribbled it down when I was looking at it because it just occurred to me that that was a discussion they were having back in May 9th, 2022, that Mr. Seveny was either aware of or was participating in which they were specifically addressing the sufficiency of the drainage plan. And I am always thinking about timing issues and the 30-day appeal issue, so it struck me as something relevant to this discussion of who knew what when and when you would have to bring up an issue. If somebody thought that what the code enforcement office or what the town was doing wasn't correct, I mean, that would be the time when you found out about it back in May of 2022, not February of 2023 when this appeal was brought.
So I'm assuming that since the record, it's already been submitted to the record, that Mr. Williams does not have to stipulate to that particular email, correct? Or should he? Because he's referred to it, but he doesn't actually have it.
I think it's already part of the record in Mr.
It is.
in
Just make
Mr.
sure it's the
Seveny's-
I just want to make sure it's the same one, Leah.
Oh, yeah, I understood. And if I can ask a clarifying question of Attorney Williams, if, I don't know what the date of that email is, and I'd like to find that out, but the building permit or the building permits were issued on May 31st, 2022, and it's your submission that that email was prior to, at some point earlier in May of 2022, correct?
Yes. I think this was in preparation of my client obtaining the building permit, and that's when the discussion occurred.
Thank you.
I'm not sure if that May 9th email, Mr. Seveny may have it, but I don't think it was in his submission before this meeting. I think it was just a newly submitted email that I saw tonight, and it jumped out at me.
Because there is a May 9 email in the appeal, but it's with regard to the tree cutting.
Okay. Yeah, it was, again, it was another email that was flashed on the screen. I don't have it.
You referred to an email back and forth between Mr. Osterreider, I believe, and Mr. Seveny, and there is such an email on the bottom of the page that's heading emails regarding ponding at 15 Longwood Drive, but that's in January of 2023. Is that the one you were referring to?
No, it was an email that was not included in this packet. It was an email that I saw.
Is that one of the additional exhibits that Mr. Seveny introduced with his application?
Correct, yes. So I'm sorry, I just.
Might be number 2 or 3.
So I have 70, hearing exhibit number 1, which is from Susan Hill to Chris Osterreider and Brian Paul, and that's dated Monday, March 6, 2023. And then 70, hearing exhibit number 2, which has a subject line of forward 17 Longwood Drive dash drainage plan from John Seveny to John Seveny, but it's a forward of an email from Tyler Barter dated Friday, June 3rd. I have no other emails.
Well, let me suggest, Mr. Williams, that if you want that as an exhibit, you better make it one.
I don't have, yeah, I mean, if, again, it was something that was on the screen that I thought he was putting into evidence.
evidence, and I'm happy to put it in. If you guys want, it was supposed to be in that pile.
Why don't we have that marked as
78 number.
exhibit number 6, would it be? Okay. Ms. Rachin, do you have any questions for Mr. Williams?
I don't, thank you, Mr. Chairman.
Thank you very much, sir.
Thank you, Mr. Chairman and other members.
All right. So to discuss that email on May 9th. So what that email was between me and Brian, the email clearly stated from Brian that he was asking for two things: the drainage and grading plan, as well as the tree planting plan from the Centauri group. And in his email, he said, I have already received the grading and draining plan, reviewed it, and approved it. So what I felt when I read that is I said, well, Brian's seen it, the engineer's seen it, so I trusted them that they got the gradage and stormwater plans, reviewed them for 17 and 21 Longwood Drive, and you know, everything was on the up and up. I tried to see them, I could never find them, but again, I trusted the town that I live in. That summer was very dry, so I did not deal with a lot of drainage off of 21 or 17 until the fall hit and it rained. Not a ton, but it rained, and that's when all the flooding happened. So because, I trusted the town, I did not try to appeal the building permit because as far as I knew, there was a grading and drainage plan that the town had done. I just wasn't privy to see it. The lawyer also made note that I moved in March of 2022, which is true. I looked at the house in the fall of 2021 and visited many, many times from that point till March. Probably well over 10 times, walking the property, checking out certain areas of it. And so I had been there a lot. I also have become friends with the neighbors. They were friends with the prior owner and frequented the land a lot. So as far as, I guess, saying I don't know about the land, I got emails from neighbors that, again, knew the land, hung out on the land a lot, and could attest to the dryness or wetness of the area. I think those were his main points.
Ask the board one question.
Of course.
Okay. I mean, I don't want to get into this issue where somebody says something, then I have to say something. It's going to get into a game of last word Charlie, where we'll be here all night. However, and I also don't want to go over and over substantive issues with regards to his appeal that I don't think are jurisdictionally relevant.
Well, let's not do that then.
Exactly. So my one question to the board would be, I do have the prior property owner here tonight, Mrs. O'Donnell. If the board would like to ask Ms. O'Donnell any questions with regards to drainage, she is here and free to answer any questions that the board may have. I'm leaving that open for the board to either entertain that or not. So I do want to put that before you.
What's the sense of the board on that? Leah?
I don't have any questions at this time.
Nor do I.
I'd like to have one question for Ms. O'Donnell, if that's possible.
Good evening. My name is Sheila O'Donnell, and I was the former owner of 15 Longwood Drive for 26 years.
Right. And you've been here at the entire hearing, I take it, tonight?
Yes,
So you've heard the presentations of everybody who has spoken so far.
yes.
This ponding issue, is this a new issue, or is this an issue that has been recurrent in the 26 years or so that you owned the property beforehand?
That property is a wet property. It always has been a wet property, especially in the fall when the hurricane season hits down south and we get the heavy rains up in the east and the northeast. And it's quite dry in the summer seasons for the most part when we're out there at the fire pit doing the fire pits then. But the spring is another time when the winter melt occurs that it is very wet in those areas, and that was in my email to Bob Centauri several months ago, that's an existing problem that's always been there.
One follow-up question, if I may. I don't mean to detain you, but you've heard about the magnitude of the problem as explained in detail by Mr. Sevigny. Is this a different problem or a brand-new problem that he's been talking about, or a problem that's existed for a long time?
I don't think it's a new problem. I think it's a sporadic problem when we get significant water. Those years that we've had those abnormal rains that we get 3-4 inches in a week, and the whole neighborhood, especially on the other side, floods. And my property was wet.
Okay.
Absolutely.
Thank you. Mr. Sevigny, do you have any follow-up questions for Ms. O'Donnell? Just 1 second, Ms. O'Donnell.
Did the road ever flood over to the extent that the pictures I showed?
I have not seen flooding over the road to that extent, ever. That said, I don't know what storm these pictures were taken from, and I know I was out of the country for 6 months, and I know you've had some unprecedented weather up here. I can tell you that I've seen a great deal of flooding in that neighborhood in my 26 years, especially when we've had those unprecedented rains.
And as I said in my spot that I collected water where there's some trees where the gutter empties into, which I had seen when we looked at the house in November and throughout. It has more than doubled in size. The area where it collects drainage from my house, where the gutter empties out, there was some small ponding. Now that is more than doubled in size. Is that what you viewed as well when you saw those images, how big the ponding was?
What I saw in your drawings looked a bit exaggerated to when you had circled previous ponding in that area versus current ponding when you purchased the property. That looked markedly smaller than what I had seen when I lived there.
Thank you very much, ma'am.
You're welcome.
There is a public hearing ongoing, that's all that needs to follow up.
Just to the lawyer's point that he brought up. The permit that was issued was based on a plan, the drainage plan, that did not function properly and it caused harm. This would not have been known during the review time. So basically, the town engineer reviewed a drainage plan and approved it, but it actually did not work and it caused harm. So there is no chance to appeal that approval. And that, again, was one of the major stipulations that the planning board was worried about, that an entire stormwater plan be done on the property so they could understand it. They approved a plan that, again, you wouldn't know if it worked or not till it happens without doing a full stormwater approval plan.
Not to conflate the two issues here, but you keep referring to the permit. And in fact, you've submitted 2 permits, I believe. Which permit are you referring to when you talk about?
I'm talking about 17 and 21.
But those are 2 different permits. and they do not state the same facts that you're stating. Then you're referring to title, to 21. So 17 can be disregarded then.
21, as it reflected on the building permit, that it was based on a condition. Now, that condition is for both sites, because it's a subdivision. That's how the planning board did it. You know, it's 2 sites of a subdivision, so they referenced that subdivision on that building permit. They probably should have put it on both, but that could have been an oversight by the town.
Okay, I'll go back to the timeline. Those 2 lots were not created at the same time.
No, but it was amended together.
Next member of the public, please.
Go ahead, Mr. Chair. I think it's worth clarifying one point, and this is to Mr. Barry's point on timeline again. After the planning board issued its subdivision approval, there were applications for building permits, and before those were issued, as Mr. Paul has already talked about, the planning department reviewed a stormwater management plan for the property. It was not an as-built plan because the determination of the code office at that point was that what had been presented by Mr. Santori was adequate to allow them to determine within, which was required of them by the planning board, of whether stormwater management would be adequately taken care of. That was the decision that was left to the town engineer by the planning board. The town engineer made that decision and issued the building permits. And I think, as we've touched upon multiple times, there was no appeal taken from the issuance of those building permits. So again, I think, as Attorney Williams has added, it's all to the town's position that these overall drainage issues, because of what is actually being appealed here, that being the certificate of occupancy, are outside the scope of what this board is reviewing. But I wanted to clarify exactly what that procedure was, because I think it would be inaccurate to state that there was no stormwater management plan reviewed. There was. And again, the town engineer determined that it was adequate. People can disagree on these points, of course, but there's an appeal process that's laid out in Article 6 to deal with that. That wasn't pursued at that point, and so again, the only issue I think it's perfectly before the board here is that of the stair rail. So I'll leave it at that, but thank you.
Good evening. I'll try to make my comments quick. My name is Leslie Lindgren. I live at 22 Longwood Drive. I've lived there for 38 years. I just want to go on the record by saying that I think the planning board really dropped the ball on following up with this permit for both of these lots. I observed the representative of the Centauri Group and his land clearing person significantly studying the plot plans as the trees were being arranged to be coming down. When I spoke with him in January, when he started doing that clearing, he assured me that he would do everything that he possibly could to be a good neighbor. When I followed up with him regarding the 22 trees that he planted by hand in the lots, I asked him why he didn't plant 88 trees, and he said that 88 was an arbitrary number and 22 was going to be good enough. I have observed as a master gardener that that lot is clearing, that the new plants that are growing up in that lot this past summer and fall are primarily glossy buckthorn. Glossy buckthorn is a highly invasive species producing large amounts of seed, contributing to thicket-like growth, preventing the growth of natural plants, native plants. And my question is, how do we as citizens discover a resolution of illegal tree cutting in the Class 3 wetlands. Some of these questions probably pertain to people underneath you. If you allege that this is a property line dispute, how does this property owner resolve this with a contractor who's looking forward to selling these houses? And I would like to go on record, too, that there were numerous emails from many of the neighbors to the CEO office and the town engineer's office during this entire process, with inquiries that went unanswered, emails that went unanswered. So it's not just the 70s that have been very, very active in contacting the board and asking some questions of the CEO, but it's been a number of the other neighbors as well. Thank you.
Thank you.
Hi, I'm Laura Seveny. I own the property as well. I just wanted to say that we had been there many times, and the property that John is talking about was fairly dry, so that our kids could play back there. That was a huge selling point to us with this house. I know we didn't appeal it sooner. The timeline seems to be an issue, but when we're being told is taken care of, not to worry about it, why would we want to appeal something if we had faith in our town that it was going to be taken care of? Now we're at this point where we paid for this property in an amazing neighborhood. Everybody has been so welcoming and we love it there, but we're watching the water erode the land where our kids play. And if we can't use our backyard, that's a huge, huge part of why we bought this home. I just want you to take that into consideration when you make your decision. I thank you all for everything you do.
Thank you, ma'am. Is there anybody else that would like to say anything with respect to this this property or these issues?
I don't really want to say anything, but I feel I should. John Noyes on 26 Longwood Drive. Probably have walked by this property 3 or 4 times a day for 40 years now. The tree situation must be fixed. The drainage situation is abysmal. The picture of that corner drainage, I had never seen that in my time, any season of the year. It's going to freeze if it happens in the winter. It's going to be ice. I don't know that the ship has not sailed. It probably has, but somewhere between the citizens and the top of this town, we need recourse to make sure that this abysmal project does not complete in this current state, because this is Kennebunk, Maine. We can do it better. Thank you.
Thank you, sir. I would like to suggest that we continue this hearing until a later date, because of the issues raised require careful deliberation from us and full consideration of the impact on the appellant, and in full fairness to the appellant and to all of the parties. We really ought to make sure that we take these issues one by one and make the correct decision with the advice of our counsel. Any debate on that between the members of the board?
Mr. Chairman, I'm just trying to understand, are you saying that you want to continue our deliberations? Well, we haven't started them, but meaning sort of continue this public hearing so that we can deliberate next time? Is that what you're suggesting?
If there are any additional evidence or points that need to be introduced, then we should accept it at that time.
I think I'll play devil's advocate a little bit here. I understand that perhaps the hour is late and we don't want to get into deliberations, but my sense is that we call the public hearing. If there are folks who want to make any additional submissions, then they should absolutely do so, but that perhaps we can close the public hearing portion, and if my fellow board members are inclined to do deliberations next time, that's one thing, but I would be inclined to close the public hearing, because I think the parties have had ample time to make their case. I think we've called a public hearing. The people who were interested made their submissions, and I think that at least we can tie up or wrap up one portion of the proceedings this evening.
Mr. Berry?
Mr. McCall has made a good case for the code enforcement office. I'm just curious if either one of the code enforcement officers have anything additional to add before we close the public hearing.
Brian Paul, Code Office, Town of Kennebunk. We initially became involved in this process back in January 2022, when the lot was cleared by mistake. We initiated a code case. Oh, sorry. We initiated a code case. We requested documentation and professional surveying to be done by the applicant. He provided us with a registered design plan from a certified wetland surveyor who actually went out multiple times and examined the property, and through the course of time submitted a plan for us for revegetating and taking care of the wetland issue. In tandem, the building permit application was reviewed and approved. All internal and exterior inspections were done by either Frank or I, and we signed off on those inspections. And they are as per the 2015 IRC building code. And subsequently, we issued a certificate of occupancy rendering that building safe.
Mr. Kunkel, do you have anything to add?
Frank Kunkel, Code Officer, Kennebunk. No, I have nothing further to add at this time.
Mr. Sevigny?
May I ask Brian a question? I have two questions. Was there an escrow account created for the replanting of the trees?
There was an account established by the Centauri Land Use, the Centauri LLC, at Kennebunk Savings for $5,000, and the town of Kennebunk was named as an account on that account. There was no escrow account as you're talking about.
So if the 22 trees that are there do not take, and as Leslie mentioned, essentially a weed takes over that area, what can the town do, and is there adequate funds to replenish that forest?
We looked at the replanting plan that was submitted and found that that plan contained 22 trees. Initially started out with 88. And at the advice of Leon Blood, the wetland delineator, he advised not to go in that wetland area and plant 2-inch trees because the damage to the wetland is going to be enormous. You can't plant a 2-inch tree without heavy machinery, and which would require all the root systems and remaining vegetation to be removed, and the grid pattern would have to be established planting 88 trees, which would basically ruin that small wetland area. We opted for a smaller plan with selective planting around the buffer and inside the wetland of 22 trees, which has been done.
Right. I'm just saying, as a precautionary measure, if those 22 trees do not survive and it is overrun by weeds, what is the recourse the town can take to replenish that forest that was there?
We'd have to re-examine the wetland impact and plan accordingly.
Or, Mr. Santori being held accountable for this? Or would it be the new landowners?
He's done everything that we've asked him to do at this point, and I'm not sure of the legal aspects of holding a new property owner liable for some past violation.
Right, I agree. I believe Santori should be held accountable, and an escrow account of some sort should be created as Leon Blood had recommended, because this might not take. We may end up with basically a swamp with weeds in it.
The natural vegetation has actually come back quite nicely. Leon Blood's been out there several times and looked at the vegetation. There's new sprouts coming up from the roots, and it's coming back, in his words, immensely.
Did he make reference to the weed that Leslie referenced?
No, he did not.
I guess, is that something you can share with the neighborhood? What Leon said? As far as sending us emails? Because we all live there and we're all very worried.
Yes, absolutely.
That's not going to come back.
Yep.
You know, and somebody should be held accountable
Yep.
for cutting down a whole forest in a wetlands. And the town of Kennebunk should be the ones to hold that man accountable. And I think it's our decision here tonight whether or not we're going to do it, or if we're just going to let someone get away with it. Second question. Did you review the drainage and stormwater plan for 17 Longwood Drive?
We reviewed the plan that was submitted by John Auger, which had the driveway plan on it for 21, and it was a town engineer's recommendation and advice that it didn't apply to 17 because of the flat surface of that piece of property in compared to 21. And if needed, Centauri could submit a as-built plan, but depending on the elevation of the foundation.
Now, because we did run into a big flooding issue, I'm guessing you guys did ask him to do that plan for 17?
Yes, we have elevation plans.
From Lower Village?
Yes, for 17 and 21.
Yep, but that's not a grading and stormwater management plan, correct?
It's an elevation plan to show if there is serious problems with that piece of property with stormwater runoff. And that did not indicate that that was the case.
Even though what's occurred would say kind of the opposite of that.
Well, what that plan did show is that there's a 4.5-foot elevation difference from the property line to your garage, and that a lot of stormwater is running off your property to the property line.
Correct.
So there is multiple sources of stormwater collecting at that point.
And
we felt at the time that 17 and 21 was not the larger contributor to that stormwater.
I will agree with that in one location, but in another, there's no topography that can add to the stormwater runoff near the trail of my property.
In line with Ms. Rachin's comments, let me make a motion, and that is to close the public hearing. Ms. Rachin, how do you vote? Oh, is it seconded?
I will second that.
Yes.
I vote in favor. Thank you.
In favor of the motion?
Yes.
I vote in favor of the motion too. So the public hearing portion of this ZBA meeting is now closed.
Given the time of the evening, Mr. Chair, and some of our members are not feeling maybe at their best that they have been in the past, I suggest we continue this. In fact, it will be in the form of a motion that we continue this meeting for the rest of the agenda to a date certain. I'm gonna let one of you, let somebody decide what that would be, because it really depends on the schedule of what this room is available.
While we're figuring those logistics out, Attorney Katsioufikis, is it fair to say that because this has already been publicly noticed and the public hearing portion is concluded, that the town doesn't have to worry about re-notification at this point?
I don't think you have to worry about re-notification of abutters and all those, because everyone who presumably had an interest in this case is here this evening or has been participating by Zoom and can follow up. Certainly, post notice of the continued meeting in the town hall and wherever you normally would do that.
And no need for publication, though. I think there's also a publication requirement, but that's again, I don't think the public hearing portion has concluded, so this is just like a regular meeting next time, correct?
Correct.
Thank you.
One more question. Because we are continuing this, then it stays the period of appeal or notice to the appellant?
Right. There is no decision yet that the
Correct.
applicant can appeal from, and so it's appropriate that the one thing we have to consider is that the board has to render a decision within 30 days following the public hearing. So we do have to wrap this up within the next 30 days and then issue that written notice of decision within 7 days of the decision. But that's all that would apply.
So I guess we should find out if this room or another room is available within 30 days.
So it does have to be this room for televising purposes and streaming purposes. Can I poll the board to find out if Monday, March 20th, is that as soon as you're looking to meet, or?
I'm already throwing a wrench in things. I'm not available that day. I'm so sorry. The rest of that week, though, I am. If the room is available and others are as well.
Do you have available dates?
I'm taking a look through my calendar, and I think we can manage that.
Leah, how about the 21st?
I can do that. If it's possible, I'm double booked that night, but I can make arrangements. But is there any possibility for the 22nd, the 23rd, or the 27th by chance?
So the 22nd is a definite no. The 23rd, for our televising purposes, the production team that I have here tonight is unavailable. I would not know the availability of any backup, so I wouldn't want to commit to the 23rd.
27th, is that feasible?
Planning board is the 27th in this room. The 28th is the select board in this room.
Boy.
29th.
What about the 15th or the 16th? Is that too soon?
So the 15th,
Or I could do the 14th, 15th, or 16th.
yeah, 16 would be out. We do have a meeting in here scheduled that needs to be televised. The 15th production, that's out.
Is that charter?
No, charter's the 8th, but our production team is spread out across several communities. Okay.
What's that on the 21st
29th or
again?
30th. And Leah, you were double booked on the 21st, is that correct? Yep, that's okay. So 29th or 30th? And how about production? Great. Just Thursday, March 30th for the two of you
Yes.
as well? Attorney Katsifikis.
I can do that.
Attorney McCall. Wow. 30th.
Going once, going twice.
Will that be at 6:30?
Yes.
Would it assist the board at all if I were to put together a draft decision on the 3 points with the recommendation that I'd made earlier?
I think that would be fine, of course, you know, we will and use our independent
Absolutely.
judgment, but there's nothing wrong with, I think, having a draft sort of based on the conversations that we've already had. At least that's my 2 cents.
I agree.
And in advance of that meeting, too, perhaps the town could circulate copies of those exhibits that you don't already have, so you, thank you.
Just to clarify, all submissions are closed then, correct? Everybody's happy with that? Okay, thank you.
Public hearing's closed, all submissions are closed, the record is what it is. Okay, is there a motion?
Okay, I go back to my original motion to continue this meeting for the remainder of the agenda for Thursday, March 30th at 6:30 PM.
Seconded.
Oh, one clarification, we do have minutes to look at. Do we want to continue that as well over to the next meeting?
Yes, that's the rest of this agenda would be continued.
Perfect.
How do you vote, Ms. Rachin?
I vote in favor.
As do I.
I vote in favor of that motion too, so it's unanimous. Hearing is concluded. Thank you.
We all good?
Thank you.
Thank you, everybody.
Thanks.